Welcome, future silks and aspiring barristers. In this explainer, we are diving deep into the federal court rules on pleadings and particulars. Look, this isn't just about ticking boxes for your exams. This is the absolute foundational knowledge you will use every single day in practice at the bar. Okay, here's our game plan. We're going to start with the pleading timeline. These are the deadlines you just can't miss. Then we'll get right into the heart of what particulars are and, frankly, why they can make or break your case. We'll cover the absolute must-haves for those really high-stakes allegations, the nitty-gritty of pleading damages, and finally, what to do when your opponent's case is just a vague mess. So, first things first, let's start with the fundamentals in Division 16.3, the deadlines. Think of this as the rhythm of litigation. Knowing these numbers by heart is completely non-negotiable. 28. This is the first number I want you to burn into your memory. It's your primary deadline. It's the one that kicks everything off the second a statement of claim is served on your client. You could say it's the starting gun for the whole race. That's right. Rule 1632 gives a respondent exactly 28 days to file and serve their defense. Memorize that rule, Rule 1632, because missing that deadline without getting an extension can be, well, disastrous. 14. Okay, so once that defense lands on your desk, the clock actually resets, and this new number comes into play. The ball is now back in the applicant's court, but let me tell you, the window to act is a lot shorter.
So if you're the applicant and you need to respond to some new facts that were raised in the defense, Rule 1633 gives you just 14 days to file what's called a reply. It is a very tight, hard deadline, so commit Rule 1633 to memory.
So let's just trace that whole sequence, shall we? The statement of claims starts that 28-day clock under Rule 16.32. Then, the filed defense starts a new 14-day clock under Rule 16.33, and once the time for that reply runs out, Rule 16.12 tells us that pleadings are officially closed. That's a really critical milestone in any proceeding. All right, let's move on to Division 16.4 and see how this all builds. We're shifting gears now from the timeline to the actual substance of your arguments. And trust me, this is where cases are properly shaped and, honestly, where they can completely fall apart. So what in the world are particulars? Well, think of them as the details that add the color and the meaning to the broad allegations in a pleading. And get this, under Rule 1641(1), they are not optional. The rule is mandatory. It says a party must state the necessary particulars. Now, this really gets to the core of why particulars are so incredibly important. You see, they're the bedrock of procedural fairness. They're designed to prevent what we call a trial by ambush. Their whole purpose is to force each side to lay their cards on the table, to make sure the other party knows exactly what case they have to meet so they can gather the right evidence and not get caught by surprise at the hearing. And understanding this distinction is absolutely critical. Your pleadings state the what, the essential material facts of your case. Particulars, on the other hand, provide the how and the why behind those facts. But you have to remember this key limitation. Particulars cannot be used to plug a hole in a bad pleading. If a material fact is missing from your pleading, no amount of detail in the world is going to save your claim. Okay, now we are getting to the really serious stuff. Some allegations are so significant, so potentially damaging to a person's reputation, that the rules impose a much higher non-negotiable burden of particularity. If you get this wrong, your pleading is at serious risk of being struck out. The key rule to burn into your memory here is Rule 1642. When you are pleading any of the serious matters that it lists, you absolutely must state the particular facts you are relying on. There is zero room for being vague here. And here is the list from Rule 1642. These are the big ones. Any allegation of fraud, misrepresentation, breach of trust, or any of the others on this list immediately triggers this heightened pleading requirement. I can guarantee you an examiner will expect you to know this list and the rule that governs it, Rule 1642. So this leads us to another tricky but really critical area. You know, it's one thing to allege that someone did something. It's a whole other thing to allege what was going on inside their head. And this is where Rule 16.43 comes in, which deals with pleading a condition of mind. Rule 16.43 is incredibly explicit on this. You can't just throw around words like knowledge or fraudulent intention. No, you are required to provide particulars of the facts from which that state of mind is supposed to be inferred. And crucially, if you're pleading constructive knowledge, that someone ought to have known something, Rule 16.43, Subrule 2, requires you to spell out the very facts that should have put them on notice. And look, this isn't just some academic exercise. The full court in Young v. Mann really shows us why Rule 1643 has so much teeth in the real world. As the court pointed out, proving a director's actual knowledge is often the key to pinning personal liability on them. So the courts demand this clarity right from day one, especially when a director's personal assets are on the line. All right, let's talk about money. When you're claiming damages for your client, you can't just pluck a figure out of thin air. Rule 16.44 sets out very specific requirements for how you must plead those damages. The guiding principle of Rule 16.44 is, you guessed it, fairness. Subrule 1 makes sure the defendant has crystal clear notice of any specific out-of-pocket expenses being claimed, and Subrule 2 requires full particulars for any claim of exemplary damages, which are really designed to punish and deter bad behavior. It's all about forcing clarity so the other side understands their total financial exposure. So what happens when you're on the receiving end of a vague, generalized pleading that leaves you completely guessing? You can't properly advise your client or even prepare a defense. Well, the answer lies in Rule 16.45. Now, to get an order for what we call further and better particulars under Rule 16.45, you have to satisfy this three-part test. It's not enough to just say the pleading is a bit thin. You've got to show that it fails to give you fair notice, that this failure is going to cause you prejudice, and that an order is absolutely necessary for you to properly conduct your case. And pay very close attention here, both for your exams and for practice. The court sets a very high threshold. In particular, Rule 16.4522b is a tough one. You have to convince a judge that you literally cannot conduct your case without these particulars. It's a really high bar, and it's designed that way to stop parties from using these requests as a tactical weapon just to cause delay. So in the end, these rules, from the timelines in 1632 to that high bar in 1645, they're not just technicalities, they are the absolute foundation of successful litigation. Your pleadings are the architectural blueprint for your entire case. Mastering these rules isn't just about passing an exam, it's about mastering the first, and I would say most critical, step toward victory in court.